Hi, my name is Josh Freeman. I am an attorney with Freeman Lovell, and we are a firm that specializes in helping entrepreneurs and small businesses to understand and take the right legal risks. Um, Thanks for joining us. This is part of our presentation on From Idea to Exit, where we're teaching entrepreneurs and small business owners the legal principles of how to structure, scale, and sell your business. And so right now we've been talking about structuring your business and what the proper way to do that is with your entity. And we're going to continue on in that discussion a little bit. So we've been talking about controlling your cap table. And basically what this means is controlling who owns what equity and what rights of repurchase and other things like that the company has, to make sure that you can control your ownership in a way that allows for the company to grow and develop and reach the potential that it has. So we've already done videos and talked about equity splits, investing. We've talked about buy sell provisions. We've talked about rights of first refusal. Today we're going to talk about the for cause repurchase rights. So basically what these are is there are times in your company where people are going down the road and owners make actions that are not in the best interest of the company. And when those things occur, sometimes it is in the best interest of the company to distance themselves from that owner and to purchase that equity back. And so one of the provisions that we advise our clients to have in their operating or shareholder agreements is a for cause repurchase right. Basically, what this means is if an owner of the business is convicted or engages in activity that is, a felony level offense, then that gives the right to the company to elect to repurchase the equity of that owner. Another one is if they're convicted or engage in acts that could lead to a conviction on a misdemeanor level involving fraud, embezzlement, dishonesty, or kind of gross immoral conduct, and those kinds of things would also give rise to this repurchase right. And then another regular trigger is if there's a material breach that goes uncured of the operating or shareholder agreement or other agreement with that owner between them and the company. In for purchase or for cause repurchase rights, sometimes there will be provisions that allow for repurchase, for regular mismanagement, incompetence, other things like that, for people who have active engagement roles. And so there may be a little more that goes into that. But the idea is if someone does something that materially hurts the company and hurts its reputation, then there needs to be an ability for the company to rebuy their equity. And a lot of times in operating and shareholder agreements, there is a provision that allows for this to happen at a reduced rate. And so, excuse me. We see that happening a lot of times kind of at 50% of the fair market value of the equity that owner owns, but that fluctuates. I've seen it as low as a 20% discount and as high as a 80% discount. So it can fluctuate depending on kind of what the owners are looking for and what they want to do that way. But yes, so these are kind of the common things that go into a for cause repurchase right, and it's something that each company should carefully evaluate having in their operating agreement or shareholder agreement. But yeah, so that leads me to the end of the deep dive, kind of into that provision and some more details on that. Again, my name is Josh Freeman. I'm a partner at Freeman Lovell. And thank you for taking the time to learn a little bit more about how to structure, scale, and sell your business. And if you have any questions, you can reach me at the email address on the screen there, or at our website, freemanlovell.com. And Thank you again, and good luck.